let's get started. For those of you that may have questions throughout this webinar, please keep in mind that we will be allowing for Q&A towards the end of the presentation. And so I'll pull up a Q&A window where you can pose your questions, and I'll try to get to as many of those as possible. And for those of you that have never attended one of our webinars before, the agenda for today, first of all, I'm going to give you some background with regards to who we are and why we're putting on this educational webinar for you. We're going to discuss some alarming industry trends with regards to how healthcare practitioners, particularly veterinarians, are getting into some of the most complicated lease agreements and why these lease agreements have provisions that will impact you financially and from a legal liability standpoint. We're also going to discuss why the lease is important. We're going to go over some of the most common traps found in lease agreements. Key considerations for those of you that are thinking about either starting a practice, buying or selling a practice. We'll discuss some of the key considerations that you should be aware of if you're planning on either building a new clinic or alternatively relocating, expanding, or selling your existing one. We're going to go over as well what's called a tenant lease cycle. It's really a concept with regards to how you should start the negotiation process and why it's important to start that process early and when is the ideal time to start negotiating your lease agreement. We'll get to that. We're also going to go over at a high level our 7-step process that we've developed over the last 22 years in helping animal health practitioners obtain a better lease agreement. And you can apply some of these same steps if your lease is coming up for renewal or if you're about to undergo the journey of starting up a practice and are about to enter into negotiation with a landlord. And last but not least, we're going to allow you to pose your questions for me so that I can address those, as many of those as possible by the end of today's presentation. So some industry trends, over 75% of veterinarians have signed an office lease agreement that can prevent them from transferring their lease agreement to somebody else and even being able to sell their practice because of landlord interference. So it's quite alarming when you think about it. The animal health practitioners who engage in lease renewal negotiations without understanding complex lease provisions do end up paying hundreds of thousands of dollars in unnecessary rent increases over their career. And practitioners are the least risky, in our opinion, type of commercial tenant as a landlord. If you're a landlord today, it is beneficial to have a healthcare practitioner as a tenant. Well, number one, healthcare practitioners in comparison to other small businesses have low default and bankruptcy rates. Significant investment in leaseholds. For those of you that have undergone the journey of building your clinic from scratch, you're really well aware of the fact that it took a lot of money and effort and time to build up the value, and not to mention the investment you made in the trade fixtures and the leasehold improvements. And that's quite a significant investment that goes towards improving the value of the landlord's building. You also generate foot traffic. Your clients certainly are visiting other neighboring tenants within a plaza or building, and that in the end results in increased property value for not only the landlord but also allows the co-tenants in your space to benefit from the additional traffic that you generate as a result of running your business in the location that you're in today. I think it's important to discuss why we're delivering this webinar. We are an organization that was founded by healthcare professionals in 1994. We analyze thousands of office lease agreements every single year, and we have represented last year alone more than 1,000 healthcare practitioners. These are a combination of tenants as well as doctors that own and occupy their building. And we've successfully negotiated over 12,000 office leases over the past 2 decades. And we conduct over 150 educational seminars annually, and we participate in various conferences, many of which you all attend. And today we are proud to be the premier healthcare tenant representation firm for veterinarians in North America. And hence why many of you have actually heard about Seraphs through Henry Schein Animal Health being a major distributor of products and services to your clinic. They saw the need to partner with Seraphs in delivering this very important message, which is taking the appropriate steps to obtain a better lease agreement for your practice so that you don't overpay in rent and that you don't increase the liability of your practice. The slide before you is a subset of the customers we have worked with all across North America. We have had the privilege of working with many of your colleagues, whether they have undergone the journey of starting a clinic from scratch, relocating their office because they wanted to do so. We have also worked with doctors that have undergone a practice transition. They've sold their practice and have had a need to be able to transfer their lease agreement to the incoming doctor, as well as many veterinarians that have gone through a renewal. We've worked with many across the country and have helped them reduce their overhead expense while minimizing their liability. So with that said, and before we dive into the components of a lease agreement, why it's important to track the critical dates of your lease agreement, what is a lease? I asked this question to countless doctors. I pose this question to them during my lectures, both in person as well as at study clubs and various conferences. And I typically am told that a lease is a contract, and it's absolutely true. And I think the way that most of you think about a lease agreement is a financial obligation. And for some of you, you believe that that financial obligation is an excessive one, and you wish that your rental rate perhaps could be a little bit lower, if not a lot lower. For other doctors, a lease agreement represents a binding contract that stipulates their end of the bargain and what they're responsible for within a building and what the landlord's going to take care of. For example, if the HVAC unit breaks down, who takes care of that? So the simplest way I can describe a lease agreement to you is that it's like a check, because like a lease agreement, a check identifies how much you pay, who you make that payment to, and when that payment occurs. The difference between a lease agreement and a check is that, unlike a check, the lease actually comes with a lot of strings attached. There's countless number of provisions within a lease agreement that will either increase your practice liability as a veterinarian or reduce your liability. So we'll get to some of those in a moment. But it's important not to look at the lease agreement simply as a financial obligation, but also recognize that it is a governing contract that will impact your liability as a practitioner. And if something does happen, unfortunately, the lease agreement is the document that will govern what happens with regards to the repair of the building, but also what occurs if, for example, the landlord decides to sue you for negligence. What does the lease agreement say with regards to that? And whose fault is it for that event occurring? So why is the lease so important? First and foremost, we know that it's a significant investment today to build a veterinary clinic. It's really the foundation of the practice, because if you're not owning your space, when you come in the office on a Friday or Monday and turn on the lights, you're walking into somebody else's building. And so without that contract in place, which is called a lease agreement, you wouldn't have the ability to have some security in your location. We also know it's very difficult to move. This is why the lease is important. You know, I have a doctor right now who called me and said, Dina, I've been month to month, meaning my lease has already expired. I've been month to month for the last year and a half because my landlord wants to sell the building, and I have decided that I want to get on a long-term lease, but my landlord is not willing to give me a long-term lease. So his consideration is whether or not he should stay with this unpredictable path or perhaps relocate his practice. But he knows that it's very difficult and time-consuming to move his clinic. it's going to cost him more than $350,000 to move his clinic, which occupies, over 1,500 square feet. So it's also time-consuming, as I mentioned, because it's not easy to find a location immediately that's available. You have to go through permitting and zoning. You have to go through construction and design, and you also have to make sure that that location is ideal for the type of practice that you're going to run and the type of patients you're going to attract. And then for every mile that you're moving away from your existing location, you do have patient attrition. So from that perspective, we know that it's important when you're thinking about relocating to look at the lease agreement and also determine whether or not there's any sort of restrictive covenant in the lease with regards to where you can move to, because some landlords actually state that you cannot move your office or open a second or third location within certain mile radius or kilometer radius of where your existing office is located. And the fear there from the landlord's perspective is that you're going to cannibalize your existing office's production if you open up another office within its vicinity. So some of you that are thinking about relocating may be interested in doing so, but you're going to keep your existing office running for a while. And so there's that overlap, and how does the lease agreement play into that? What are the benefits of a properly negotiated lease? There's many benefits. First and foremost, for having a lease agreement, one of the things you're looking to achieve really is fair and affordable financial terms, right? You want to know whether or not you're going to have to pay a base rent plus your proportionate share of the operating expenses for the building. Many of you are not aware of what type of lease you have, whether it's a gross lease or a triple net lease agreement or a modified gross lease agreement. There's differences between different types of lease agreements. And understanding the type of lease agreement you have is really a starting point for allowing yourself to better negotiate a deal with the landlord, because you're going to want to know, is my rental rate predictable? Is my rent going to go up or down over time, and how much is it going to increase by? And when I exercise my option to renew, how is the rental rate determined at that point? You also want to have a properly negotiated lease because you want long-term stability. The ideal term on a lease agreement for a veterinarian is a 10-year term with ideally 2 or 3 options to renew that lease for periods of 5 years each. So therefore giving you 25 years of predictability and long-term stability in the location. If you have a lease agreement that is coming up for renewal, it's important to try and reset the clock, but don't simply exercise your option, because if you exercise your option to renew, then you are in a position where you have less term left. So instead of exercising the option, we recommend asking the landlord for a brand new term. That could be a 10-year term plus additional options to renew, so that you can continue practicing in the location and one day hope to sell the practice and provide the buyer with predictability and stability. The lease should also minimize your risk and exposure. And the majority of the doctors whose leases I review have signed it in their personal names, and that means that they're telling the landlord, in essence, that their liability and the business liability and their personal liability to pay the rent are one and the same. So when we negotiate lease agreements, if it's properly negotiated, we have ideally a corporation listed as a tenant, not an individual doctor, so that we are sheltering their personal assets from any sort of liability on the lease agreement. And this obligation to pay rent, if the business doesn't work out, it becomes a business problem, not a personal problem that you have to take care of. You also want to maximize your flexibility to be able to sell the clinic. And in every lease agreement, there's provisions that dictate whether or not the landlord will allow you to transfer the lease to somebody else. And you also want to have provisions in your lease agreement that allow you to sublease in a fair manner and to be able to charge a rental rate that you deem to be appropriate for your unit if you're going to sublease that space. Now, we're going to get into what is a lease agreement, because I think for the most part, the individuals that have attended today's webinar across North America are mostly interested in, number one, knowing when to start negotiating a lease agreement if they have an existing location, and number two, you're interested in knowing what's in my lease. And so I could probably run a 2-week workshop just on provisions within lease agreements, but for the purposes of today's presentation, I'm going to cover some of the major provisions that we come across all the time. The first one, if you're thinking about renewing a lease and you want to make sure you don't miss your deadline to renew, is entitled option to renew. This provision in your lease agreement, it should be in your lease agreement. It's found in more than 90% of lease agreements. If it isn't, then it means you don't have an option to renew the lease. But if you have an option to renew the lease agreement, you want to identify how that option is to be exercised and when it's to be exercised, if you're going to exercise it. Now, we commonly find in the lease agreements there's some traps in the option to renew that the landlord has set up for their own benefit, essentially to have the tenant be in a position where they don't have much leverage when they exercise the option. So the first thing you'll notice here is that it states the option to renew is personal. In essence, what it states, and we've taken out the name of the actual doctor whose lease agreement we reviewed, replaced it with that of Dr. Joe Black to protect their confidentiality. But the lease agreement that we reviewed, this provision you see in front of your screen, is taken directly from that lease. And what it says is that provided that Dr. Joe Black shall remain as the tenant. So what this means is that if you're buying a clinic and you end up inheriting somebody else's lease agreement, the option to renew in this case is personal to the previous doctor. So the buyer of the clinic cannot exercise that option. The option becomes null and void upon the sale of the practice if the lease is assigned. So this is one trap in options to renew. Another one is this idea that if you've ever been late paying rent, if you've defaulted under the lease agreement, the landlord has held you in default, then you don't have the ability to exercise the option to renew. Most lease agreements state that if you have been in default and the landlord has held you in default of the lease, then you cannot exercise the option. And most doctors, by the way, are not required to be notified, interestingly enough, when they're in default. Meaning you could be in default without knowing it. Right? The landlord will document this. When I was on the landlord side, we would document every single time a tenant went into default to have an idea of essentially whether or not we would want to renew the lease. And if we did want to renew the lease, we may want to renew it on our own terms without allowing the doctor to exercise their option to renew. And if you do renew the lease agreement, most lease agreements state that if you renew the lease, that such renewal shall be on the landlord's then standard form lease. So what this means is that regardless of the lease agreement that you have signed previously, when you exercise your option to renew, the landlord has the ability to rip up your existing lease agreement and put a brand new lease in front of you, one you've never seen before. And the only reason why the landlord would want to do this is to have a lease agreement that's more onerous. Right? Lease agreements are typically updated by landlords over time, and so the reason why the landlord during renewal time will want you to sign their then current standard form lease is to allow themselves to essentially have a better lease agreement for their business, and one that is often one-sided. And last but not least, this provision states that if you end up renewing the lease agreement, in no event shall the rental rate be less than the rental rate paid in the original term. So for those of you that are in a situation where you feel that you're overpaying in rent, exercising your option to renew is not the solution, because most of your options to renew provisions in your lease agreement state that if you exercise the option, in no event will your rental rate ever decrease. And so instead of exercising the option, what I would recommend is contacting the landlord, ideally 2 years in advance, and negotiating a brand new term, because if you exercise the option, well, you don't have the luxury of negotiating the rent down. The landlord, if you exercise the option, is going to go by what the option to renew provision says in your lease. And if one of the rules is that your rental rate will never decrease, then the landlord is not going to offer you a rent reduction. And if the landlord and tenant, let's say the landlord comes to you and says to you, doctor, congratulations, you've been paying $31 a square foot per year, your rental rate is going up to $36. If you choose not to accept that rental rate, some lease agreements state how the rent is to be determined. In this case, it will be determined by arbitration if the landlord and the tenant don't see eye to eye with regards to what the rental rate should be, but the arbitration process takes into account market rent for renewing tenants in the building, not within the market, but within the actual building you're located in. So if the tenant next door decides to renew their lease agreement and ends up paying a higher rental rate, that will have a direct correlation with your rent, because your lease agreement states that if you don't agree with the rental rate the landlord proposes, the landlord is going to take the rental rates for renewing tenants in the building and use that to benchmark your rental rate through the arbitration process. So having a lease agreement that has rental rates based on renewing tenants in the building is not good, because if other tenants in the building end up paying higher rental rates, they will in turn drive up your rent. The next provision I want to discuss today is called assignment. And the assignment provision is the provision in your lease agreement that determines how you're able to assign or transfer your obligations as a tenant to some other entity, whether that be a practitioner or perhaps a corporation. And assignment provisions are found in approximately 75% of the leases that we review. You want to have an assignment provision in a lease, because if you don't have one, then there's no ability for you to assign or transfer your lease agreement as part of your practice transition. And this paragraph was taken directly from another lease agreement that we reviewed here at the firm. And what we noticed first and foremost is that in order to transfer the lease, you need to have the landlord's consent. In fact, there's no lease agreement I've ever reviewed during my career that states that you can assign the lease without the landlord's consent. It always requires the landlord's permission if you're planning on transferring your lease agreement to somebody else. Now, if you transfer the lease agreement to another practitioner, some landlords have the ability to terminate your lease agreement if you decide to assign it. Meaning, instead of agreeing to allowing you to transfer the lease, they have the ability to terminate your agreement. And the reason why they want to do that, very simply, is because they want to list the space on the market. The way they look at it is, if you're planning on assigning your lease to some other tenant, well, then there's a tenant or demand for that space. And because the landlord owns the space, they would much rather have you relinquish or have them to recapture the space rather than allowing you to put up on the market or alternatively to assign it to somebody else. And so from that perspective, you want to pay attention to whether or not your landlord has the right to terminate if you request a transfer of the lease, or has the right to recapture your space upon your request to transfer the lease agreement. Now, alternatively, the landlord, instead of agreeing to terminating the lease, could re-up the rent, meaning they could agree to the transfer, but they could ask the incoming tenant, the individual doctor you're trying to assign your lease to pay them more rent. So another common trap within the assignment provision is this mechanism which allows the landlord to collect more rent upon a transference of the lease. Now, the majority of the doctors whose leases we review, if they are successful in assigning their lease agreements, based on the way their standard lease is written by the landlord, in no way, shape, or form would they be relieved of any liability if they transfer the lease. So we also pay attention to this, because if you're looking to sell your clinic and you're needing to assign the lease agreement because the buyer needs term, the last thing you want is to be liable for the default of the buyer throughout the balance of the remaining term. And this is what we call continuous liability. Continuous liability means you have liability even after you have transferred your lease agreement to another veterinarian. And this is something we ideally want to remove from the lease agreement. If the landlord is not willing to remove it, we want to limit it to a certain duration of time or certain dollar amount. There are dozens of other tracks within the office lease agreement. Because our webinar is only 60 minutes today, we're not going to go through all of them. But if there's two provisions or areas of the lease that you should pay close attention to, there are the option to renew provision and the assignment provision. These two provisions, if you can read them and understand what they say in your lease agreement, will save you a lot of money and a lot of headache. Now, for some of you that are on today's webinar, you're looking to start up a clinic. And there's some key terms that you want to pay attention to and some attributes within the lease agreement. The first one is rental rates. You want to have fair and affordable rental rates. You want to research the market and find out what the going rates are. You want to get the landlord to ideally contribute towards the build out of the clinic. And this comes in the way of a tenant improvement allowance. Now, the majority of the tenants that are negotiating these improvement allowances unfortunately negotiate these without negotiating the rental rate first. So what often happens is you go to the landlord and you say to the landlord, I want an $80,000 contribution from you to build my veterinary clinic. And the landlord generally will give you that money, but what they're going to do is they're going to factor that into your rental rate, meaning they're going to quote you a higher rental rate because they're granting a tenant improvement allowance. So those allowances are not free, they're factored into your rent, and they're essentially a loan. And the way to negotiate them is to negotiate them after negotiating the base rental rate, so that you are aware of what the delta is and you can determine whether or not it's cheaper to go to the bank and obtain that financing or capital from the bank instead of your landlord because it's more expensive to get it from the landlord. You also want, if you're building a clinic, you want a fixturing period. The fixturing period is a time period you have as a tenant to install your trade fixtures and build out your clinic. And during that time period, you're not paying any base rent. You may be paying for utilities, but you're not paying any base rent. And the longer the fixturing period, the more beneficial it is for the business owner because of the fact that it takes time for you to actually build out your clinic. It's not like starting up a convenience store. Your process for selecting a location, permitting and zoning, construction design, and equipping the practice is not a short one, it's a long one. And so the landlord has to recognize that and ideally provide you with anywhere from 60 days to as much as 180 days, in some cases even more, a fixturing period depending on where you're looking to start up the clinic. And last but not least, you want to have conditions in your lease agreement that are fair to both parties. And the way standard form leases are designed, they're designed in favor of the landlord. And when you're working with a broker, the broker who gets paid by the landlord is not in a position to negotiate the proper terms, proper legal terms in your lease agreement because they're getting compensated by the landlord through a commission, and that commission is tied to your rental rate. And for those doctors that are thinking about transitioning, you want to, as I mentioned before, have lots of term because when you sell the clinic, the buyer needs to have, generally speaking, at least 7 years of term left on the lease in order to obtain financing from the bank. The banks are amortizing the practice loan over the duration of the lease term because the lease term is the only thing that's giving them predictability that the doctor will pay back the loan aside from their personal covenant. You want to also have options to renew, ideally options that are transferable to the next tenant. If you sign personal guarantees and you're looking to sell your clinic, ideally you want to remove those guarantees well before selling your practice because personal guarantees mean that if your business isn't successful, you're the one who's going to have to pay the landlord personally. And if you have liability after a transfer of the lease agreement, then if the buyer of your clinic defaults, you could also be personally held liable for having to pay the landlord or cover the expense they're going to incur in leasing the space to somebody else and finding another tenant. You also want to have a clean assignment provision that allows you to transfer the lease agreement to the next dentist. And you should have, whether you're a 65-year-old doctor looking to sell or a 33-year-old doctor looking to buy a clinic, you need to have a death and disability clause in your lease agreement. A death and disability clause is a provision that we developed which essentially allows you, the tenant, to be able to terminate the lease agreement if you become disabled, or upon your death, it allows your estate to be able to terminate your agreement without any ongoing liability. That's assuming if you're not able to assign the lease. Ideally, your estate assigns the lease agreement to the next operator, but if you're not able to find a buyer for the clinic, this early termination right really allows you and your estate to walk away without incurring significant amount of risk and liability. So if you're thinking about starting negotiations, some of the traps that most doctors fall into is starting the process late when they're dealing with a landlord. The ideal time to start negotiating a lease agreement, if you're thinking about renewing a lease, is approximately 24 months prior to the expiration of the current term. So, for example, your lease expires in 2019, you have one option to renew for 5 years. Just because you have an option to renew, it doesn't mean that you should leave it till last minute to negotiate the lease. Options to renew typically have a deadline, and oftentimes are not beneficial to exercise. So you want to start the process. If your lease expires in, say, 2019, you want to start the process now, 2 years approximately prior to the expiry of the current term, not the option for new term, the current term. And the closer you get to the expiration of your current term, the less leverage you have as a tenant. And the reason why we advise doctors to start negotiating 24 months in advance is very simple. It could take you as much as a year, believe it or not, to negotiate a lease properly. Now, obviously, when we have a client who has a lease that expires in 6 months, we assign more lawyers and more negotiators and resources to the task, and we're able to do that negotiation in a shorter time frame. But most doctors who are leading the lease negotiation till the last minute are having to rush through the process and are not properly addressing the areas of the lease that need attention. They may pay attention to the rental rate, but they're not even bringing up any of the provisions that I discussed before. And if all else fails, if you start negotiating 2 years in advance, and it takes you a year to figure out whether or not the landlord will agree to all the changes, if all else fails, you have a year of remaining term that you could spend finding an alternative location if you decide to relocate because you don't like the deal the landlord is giving you. But you don't have that luxury if you're starting the process 6 months in advance of the expiration of the current term. And most landlords are smart enough to know that you're not going to be able to relocate your clinic in 2 months. So another reason why it's beneficial to start the process is to let the landlord know early on that you have sufficient time to plan for a relocation if the terms of the offer they're making don't make any sense and you cannot afford to pay the asking rental rates. And as far as how to go about negotiating a lease agreement, if anybody wants to have us walk them through this in more detail, I'll be more than happy to do so. But in a nutshell, we have a 7-step process that we follow, and you can follow the same step process. We first and foremost gather all the documentation pertaining to the negotiation. So that means that if you've been in the building, for example, for 28 years, and you originally signed a 5-year lease, we obtain that original 5-year lease agreement. We don't just rely on a copy of the renewal agreement to start negotiating with the landlord. It's very important to have the entire history of the negotiations, past negotiations, reviewed and documented so that when you contact the landlord, you're aware of what issues, concerns, and problems have been brought up before, and you're also aware of how a renewal or an amendment agreement ties into the original lease agreement and why it's important to understand what the original lease says, not just what the amending agreement says. After we've gathered all the documentation, we then review the lease agreement from cover to cover. We identify the provisions that are most important, and we then do market research. So after reviewing the lease agreement, looking at the legal terms, we then look at what are the going rates in my area? What is the vacancy rate in my building? What available properties are there, and what are the rental rates that landlords are leasing these locations at? And how much are the tenants, existing tenants in these properties, paying in rent? After we've done the market research, we've already done the legal review, done the market research, then we start prioritizing what we're going to discuss with the landlord. And the reason why we do this is because we don't want to send the landlord a laundry list of requests without strategizing as to what is it that the landlord is looking for in my case. And also, if I tell the landlord that I need exclusivity for my business to be the only practitioner in this building, or alternatively, I need to be able to terminate my lease because of a health concern, what am I telling the landlord? Because if you bring that up early on in the negotiation process, the landlord will likely know that this is something that you're thinking of doing. And if it's important to you, they're going to make you pay for it. So don't always bring up the most important items in the beginning of the negotiation. A lot of this is really a chess game, right? You don't want to give away your strategy or show your hand at poker when you're playing with a very savvy real estate professional. Now, steps 1 through 4, gathering documentation, reviewing the lease for risks, market research, and outcome development, haven't required us calling the landlord. Yet what most of your colleagues are doing is they're picking up the phone when they realize their lease is coming up for renewal, and they're starting to verbally negotiate with the landlord without having a clear sense of what their objectives are. And so we find that if you spend a lot of time preparing for the negotiation is going to go a lot more smoothly. And you can rest assured that the landlord is very well prepared for the negotiation that you're about to have. So there's benefit in preparing as much as the landlord has prepared, and they certainly know their building well, and they certainly know the rental rates in the area, and they certainly have read the lease agreement. Why? Because they were the one who designed it with involvement from their legal counsel. So once we pick up the phone, this is where we start negotiating the rental rates with the landlord. Now, keep in mind, I talked about how we are reviewing the lease agreement and we're looking at the legal provisions. So when we call the landlord, why is it that we're now negotiating the rent first? Very simple. Landlords want a long-term tenant and they want as high a rent as possible. If you bring up all the legal changes in your lease agreement first, you're going to lose the landlord's interest. Talk about rent, something they care about, and it's a lot easier to then get them to agree to things like allowing you to terminate the lease if you become ill, or having the ability to be able to assign your lease agreement as part of your practice transition. So once we've negotiated the rental rates and all the financials, then we start getting into all the legal terms and discussing those amendments with the landlord. And at this stage, what allows a tenant to succeed at the negotiation of the legal amendments is whether or not they have somebody on their side who's drafting those amendments. Because if you rely on the landlord to spend money and time to alter their standard lease agreement for one tenant, you'll get a lot of pushback. this is one of the reasons why landlords oftentimes tell you that they're not interested in changing your standard form lease. It's not because they're not open to hearing your ideas. It's mostly because they're not willing to spend the money on legal fees having the lease agreement rewritten for one tenant. There's a reason why they came up with a standard form lease. They want to apply a template to all lease negotiations. And although you have one lease, for most of you, if you have one office, you have one lease agreement, the landlord has many. And for them, it doesn't make sense to create a custom lease agreement for one veterinarian. So if you're going through this journey and you get to the legal end of things, make sure you have somebody on your side who's drafting such amendments for submission to the landlord and is willing to get on a call with the landlord and articulate the importance of these amendments. And last but not least, we want to finalize the negotiation by making sure that we obtain an executed copy of the lease agreement from the landlord. More than 85% of the doctors who send us their lease agreement do not have a countersigned copy of the lease agreement on file. So they negotiate the lease agreement for 4, 5, 6, 7, 8 months, maybe less, maybe more in some cases, but they fail to obtain a countersigned copy of the lease from their landlord. And so if there is flood damage or they need to file an insurance claim, that contract they have in their file cabinet is not technically legally binding. Why? Because it only has the signature of one party on it. So to summarize today's presentation, the details in your lease agreement can cost you hundreds of thousands of dollars if left alone. Rent is important, but it's not just about rent. It's ensuring that you started the process early so you have leverage, and also paying attention to the legal terms of your contract with the landlord. It's also about minimizing risk, in practice, maximizing flexibility, and ideally achieving long-term peace of mind. And there's nothing more stressful than having a lease agreement that comes up for renewal every 2, 3, 4, 5 years and having to go through the landlord negotiation process every single time this lease comes up for renewal. And it's not pleasant for most of you to have to deal with the property manager or landlord. And on top of everything else you're managing, having to do this time and time again is not a smart strategy. You want to set up the lease agreement for long-term predictability. Ideally, negotiate a long-term lease agreement with multiple options to renew so that you don't have to spend a lot of energy every 4, 5, 6 years doing this process. And you want to be strategic. You don't get what you deserve. You do get what you ask for. And believe me, landlords negotiate lease agreements. Some of your colleagues may have told you, well, why would my landlord negotiate? I'm just one tenant who's leasing 2,000 square feet. But landlords will negotiate because contrary to what some people believe, for them, it's a matter of securing your tenancy. And if it means making some changes to accommodate you, they are willing to do that so long as there's something in it for them. And that's something, generally speaking, is a long-term commitment from the tenant's part. You also want to have a plan in place. You know, don't pick up the phone and start negotiating a lease agreement or fire off emails to your landlord if you don't have an action plan as to what you're going to do and when you're going to negotiate and how you're going to achieve the changes you're looking for. So with that said, I'd like to open it up for Q&A. We will take some questions, and let me pull up the chat window here so that you all can type in your questions for me. And a copy of this webinar will be provided to all of the attendees. So we will provide you with a recording of the webinar for your viewing so that you can view it again if you need to. And we also have on the bottom right-hand corner of your screen some very helpful white papers, everything from a startup guide for a doctor who's looking to build a clinic from scratch, to a veterinary practice relocation guide, to a renewal guide for those of you that are renewing your lease agreement. And on the bottom left-hand corner of your computer screen, you will see some online resources. So we have other webinars and seminars that will be scheduled. We have documents that you can read if you want some more information. And also, if anybody is interested in having their lease agreement reviewed, I will discuss that momentarily. Because of the helpful support that we've achieved from different partners in the industry, we are going to be offering the first 5 attendees that reach out to me a complimentary veterinary office lease review, which entails an assessment of your rental rates in addition to a full review of your lease agreement so that you are aware of what's in it. But I can only offer that to the first 5 attendees because this requires one of our consultants to spend a couple of hours reviewing the lease agreement and then getting on a scheduled phone call with you to go through it. So we don't have, unfortunately, 500 consultants. We only have a couple of dozen. And so for that purpose, we're only going to offer the first 5 attendees who reach out to me, and I'll put up my contact information on the screen with a complimentary lease review. If anybody else is interested in having their lease reviewed thereafter, it's a cost of $1,500 to have that happen. And I'm just noticing that a couple of you are typing in questions. Somebody wrote a question here. If my landlord has changed recently, is it a good time to negotiate the lease agreement? So when a landlord does purchase a building, there's a change in ownership of the building. Generally, the landlord wants you to sign their standard form lease, not the type of lease agreement that you've signed historically. So it could very well be, doctor, that your landlord may approach you, your new landlord, within the next couple of weeks and request that you sign onto their standard lease agreement, depending on what your past lease says. I mean, some tenants who have a new landlord, they are not required to sign a new lease agreement. Others are. It depends on what their lease agreement has stated historically with the previous owner and whether or not that lease was carried forward. And then I'll take another question here with regards to an option to renew. If I have an option to renew and it stipulates the rental rate already, what's the best strategy for negotiating is the question. So that's a great question. So when you negotiate your lease agreement and the rental rate, it looks like was preset for the option to renew period, you're asking whether or not you can still negotiate. The answer is yes. I mean, if you exercise the option, the answer is no. The landlord, essentially, you're telling the landlord, I'm exercising my option, hence the rental rates outlined in the option are what's enforced. But if you approach the landlord in advance and communicate to the landlord that you're not going to exercise the option, you're requesting a new term, then you can renegotiate the rental rate. Absolutely. So here's my contact information for anybody who wants to take advantage of the complimentary lease review, which is being offered to the first 5 attendees. And if anybody has additional questions, by all means, feel free to reach out to me via email or simply call me, and I will get back to you within the next 24 to 48 hours. And there's multiple resources available on our website. It is very content-rich, and there's a lot of videos available as well. So when you get a chance, have a look. If there's anything that you want us to provide to you as far as resources that would be helpful, let me know. We're always interested in getting feedback as we really view our website as the go-to place for doctors that are considering negotiating a lease agreement. There's also a leasing dictionary available, so for those of you that want to understand the common terms within the lease agreement, we have very simply defined the common provisions found in lease agreements and have provided a definition of these terms for you so that you don't have to go through different legal dictionaries to try and understand what these terms mean at a high level. And with that said, I'd like to thank everybody for attending today's presentation, and I hope you found it highly informative. If we can be of any assistance to you going forward, let us know.